and they are too. Uh, I, I know my client's not trying to run from this matter, Your Honor. Uh, and if this court believes that he's a threat to the community due to this being his third operating while intoxicated, there are at least preventative means and to give him a cash bond and make him stay in the county jail. Um, such as an alcohol such as an alcohol tether. So respectfully, Your Honor, we're going to ask this court for a personal bond. If this court, if the court was inclined to thinking about a cash bond, then we ask you for alcohol tether in this matter. And if he doesn't adhere to that alcohol tether, then he'll be in jail. But we're asking that he at least be able to stay out of jail at this moment to at least be able to take care of the people that depend on him in this matter, you know. And all in all, this is a non-assaultive. This is a non-assaultive allegation. I do understand that it has the potential to be a dangerous situation when somebody's operating while intoxicated. That's correct. But technically, this is a non-assaultive. These are non-assaultive allegations. He's not looking to run from this matter. He's looking to put this behind him.
Anything else, sir?
Nothing further, you know.
Detective Smilo, anything else?
No, I mean, my main concern is the public and the fact that there was 2 kids in the car. I mean, that's concerning to me for the safety of everyone involved. There's nothing personal to it. I just am trying to keep the public and his children safe from that.
And Your Honor, respectfully, if we're really concerned about the children,
Council Word, you've already made your argument. Thank you. Okay, I appreciate it. Okay, Detective Smilo, and everything that you needed to add, you added, correct?
Yes, Your Honor.
Okay. Court uses clear and convincing evidence standard when it's entertaining monetary bond. Start off with a personal bond basis. And this is for Mr. Hogan Mosley, sir. Is that your attorney is speaking about how you are responsible for a number of individuals. Sir, the court didn't put you in this situation. You put yourself in the situation. If it was just yourself, okay, no other people, all right. But in this case, you had 2 minor children in the back of a motor vehicle. It is by the grace of fate, by the grace of Allah, by the grace of God, by the grace of the universe, sir, that you did not get involved in an accident, because those 2 minor children may have been injured traumatically. Don't know, was not there. But what I do know is that you have 2 prior drinking and driving convictions, okay? And this is not like you had a .08, you had a .14, a .13, okay? And then you had the alcohol that was in the motor vehicle.
Oh, man.
Somewhere it was in, it had fallen. It was either in a cup or it was in a bottle, however it is. You placed yourself in this situation. You're the one that placed your situation that you may lose your job, okay? You may not be able to take care of the other individuals that you are responsible for, okay? So it's nobody else. And sir, after 2 drinking and driving convictions, okay, you should be aware that if you're gonna drink at home, no driving. Or if you're gonna drink, you're drinking at a party. Have somebody else designated as a driver, not you. That you shouldn't be driving at all, period. So there's nobody else when everybody's saying, you know, you're a danger, that you're responsible for other individuals. There's nobody, but it is yourself that you place in this situation. So you're gonna have an alcohol tether. And not only you have a suspended license,
yes, ma'am.
you were still caught driving when you're not supposed to be.
Yes, ma'am.
So this is nobody's fault, not your attorney, not Detective Smilo, but it's yourself, sir. Okay?
Yes,
you need to get into some sort of treatment, whatever it is that helps you. Don't put your hand out. It's not going to help if you say anything. Okay, so what I'm gonna do, sir, okay, because I did not read that there was an accident. I did not read that you hit some property. I did not read that the two minor children were injured. I did not read that you were combative with the police. So the only reason, and you're getting $100,000 personal bond, that's the only reason, okay, is that I'm concerned about the people that you're responsible, but they're not going to help you, okay? It's not going to help if, you know, they're in the hospital because you got into an accident. So the no drinking, no driving, and I'm telling you right now, if you're caught driving, even if you're caught moving the vehicle from in front of the house to the driveway or to a parking lot, okay, violation of your probation. Do you understand that?
Yes, Your Honor, I do.
There is no reason for you to be sitting behind a driver's seat. If there are machines that you work, you are not to be behind those machines, period. If it can be driven on the road, it can be driven on the workplace, you are not allowed to do that. Do you understand that?
Yes, ma'am.
Okay, so you're gonna get $100,000 personal bond, no driving, no drinking, alcohol tether. Council Bird, anything else you want to add?
Nothing further, Your Honor. Thank you.
Detective Milo, anything
Please.
else?
Yes, Your Honor. The one thing I would request is for him to seek treatment. If he's going to be out on a personal, I'd like for him to have to seek treatment upon obtaining his alcohol.
He knows that he has to have some sort of treatment program. He knows, okay? There is no treatment program that I know of, okay? So, because when he goes in front of the Canton Township District Court judge, he's not in a treatment program, his bond will probably be revoked. So I suggest that he get into a treatment program as soon as possible
Yes, Your Honor.
and start doing AA meetings.
Thank you.
And don't think Mr. Hogan Mosley that, oh, let me drive to the court. Nobody's going to be aware that I drove to the court. They will be aware that if you drive to the court, because there are cameras all around over in Canton Township. So if you think that you can drive to the court, you'll go in front, you may or may not lie because they may not ask you a question, but they're aware. Canton Township is aware. So I suggest you get into some treatment program as soon as possible. And I suggest that you get into an AA meetings or anything else that will help you. Do you understand that, sir?
Yes, and I understand the severity of the situation too.
Okay.
May I say one thing?
Please.
What's your,
please,
what,
please,
what-
please,
what?
please. If it's not
What?
about what your court dates are or your bond conditions, I advise you to exercise your right to remain silent. That's included in that police station to those police. That's included on the screen, and that's included on the phone while you're in jail.
That concludes your arraignment, Mr. Hogan Mosley.
Thank you, Your Honor.
Thank you. Okay, let's get Westland. You want to go into a breakout room?
Please, Your Honor.
To the breakout room. Do that.
We were like, what the what? Some shit about it, huh? Let's do it. You're crazy. He went. It was like, what? Put it out on video. It had nothing to do with me. It was something. him go? First part. Was it racist? Yeah. Was it racist? It's
Even more ready after I get rid of this perch,
Okay,
my perch. Wow.
okay. All right, we have Mr. Brown. So Did you want to do it here or you want to come online?
I'm about to come online. Right?
Okay. Sergeant Kozak?
Yeah,
Okay. Do you want to do through the phone or do you want to go because I have you online? You just need to
I can
unmute.
go through the phone.
Okay. I'm gonna see. Council Byrd,
Yes, Your Honor.
can you hear Sergeant Kozak, who is on the phone?
I just
Sergeant
heard him.
Kozak, say something.
Sergeant Kozak, Westland Police Department.
Can you hear him, Council Byrd?
I can hear him.
Okay, all right. The gentleman at Westland Jail, what's your name, sir?
Ramirez Brown, Your Honor.
Is it Ramirez Christopher Brown?
Yes, ma'am.
Sir, I'm Magistrator Charte, you hear criminal matter, case number 822571047601. You have an
Rights and will stay on mute.
I'm going to enter a plea of not guilty. Court dates are May 22nd, 2025, probable cause conference, followed by preliminary examination, May 29th, 2025, May 22nd, May 29th, both matters 9 o'clock at the Westland District Courthouse. Understand those court dates, Mr. Brown?
Yes, ma'am.
Sir, let me tell you some bond conditions. One is there's no assault for combative behavior. Do you understand that?
Yes, ma'am, Your Honor.
Sergeant Kozak, was there any drinking involved?
Mr. Brown was intoxicated.
He was or was not?
Was.
Okay, so, Mr. Brown, there's no drinking of any alcoholic beverages. You're not to possess them, you're not to drink any alcoholic beverages. You understand all that?
Understood, ma'am.
Sergeant Kozak, can you tell me, does Mr. Brown have any prior assaultive convictions or pending cases? I'm aware of the armed robbery conviction from 2005. Anything else other than that?
That would be the only one as of right now.
Okay. Council Byrd, go ahead, sir.
39-year-old lifelong resident of Michigan, Your Honor, 3 children. In the case that he does home improvement, his days and hours vary. He is unfortunately dealing with a serious medical condition, which he takes medication and indicates to us that he hasn't received it since he's been in jail. But hopefully we can get him out of here today, Your Honor, and we're going to ask this court for a personal bond in this matter.
Thank you. Sergeant Kozak, anything else the court needs to be aware of?
I would just like to add, Your Honor, that Mr. Brown does have 12 current outstanding warrants for his arrest right now. I do not believe that he would, with all the warrants he has, comply with court orders to return due to the fact that he still has all these outstanding warrants, 12 of them. And the situation that was involved, he did not comply with officers. They're called out there multiple times. With all this and presented in front of you, I will let the court's discretion for bond. Just with all these outstanding warrants, I do not believe he's going to comply with the court.
Okay. Sergeant Kozak, you say these are outstanding warrants. What outstanding warrants are we talking about?
He has traffic warrants. He has disorderly person warrants. He has trespass warrants. These range from the city of Romulus, the city of Inkster, the city of Dearborn.
So he's got some misdemeanors other than traffic warrants all over Wayne County.
Yes.
Okay. Council Byrd, you wanted to say something?
Yeah, Mr. Maria, Mr. Brown, can you please just?
Yes, sir. Yes, sir.
Your Honor, respectfully, I didn't hear those warrants are a failure to appear. So we can't say we don't believe that he's going to appear on this case because of those warrants. We don't know what status those warrants are in. It sounds like about 9 or 10 of them are traffic. I do understand those traffic warrants. Sometimes they get noticed, comes in the mail, and sometimes people live in different locations where the court might not have their correct address. So I haven't heard those were for failure to appear stuff. All that was stated was that he has outstanding warrants. So now that he knows about those warrants, he'll be able to clear. He'll be able to clear those. He'll be able to clear those warrants up. But unfortunately, my client may not even have known about those warrants in the first place, Your Honor.
Okay, thank you. Sergeant Kozak, other than
Yes, Your Honor.
traffic, tell me what misdemeanor cases are, and are they fail to appear?
They are failure to appear. The misdemeanor ones are the disorderly person, the trespassing, and then aside from simple civil infraction traffic, multiple GWLS and violation of child restraint law.
Those, I'm not looking at the civil infractions, which is traffic. I'm just looking at disorderly person and trespass. How old
Yes,
are those?
Two disorderly persons. One is from the 34th District Court. Date of warrant was 12/27/2023. The other disorderly person is from the 19th District Court. That warrant, the date of warrant was 12/12/2024. And then another one out of 19th District Court for the offense of trespass, 12/12/2024.
So he's got failure to appear from 2023 and two of them from 2024.
Yeah.
Okay.
Is
Council
there any
Bird,
way
you want
that-
to add anything else?
If I could please do a case lookup on it, Your Honor, because I
Yes.
would like to see. This is my first time. This is my first time hearing about those warrants, and I would like to just see the process, what stage in the proceedings they are, in which he failed to appear.
All right, I'll give you a few minutes. Go ahead, Council Bird.
Thank you. And that was out of the 18th, 19th, and 34th, Your Honor.
Sergeant?
Yeah.
18th,
34th
19th, and
District,
go ahead, say that
34th
again.
District, 34th District and 19th District.
So it's just
34th
34th and 19th?
Yes, two from the 19th District, one from the
I know.
34th District.
Okay. All
Got
right.
you. And
Council
does he know
Bird, two
the
are from the
stage of the
19th
proceeding?
district. Council Bird, two are from the 19th district and one is from the 34th district.
Got you. Thank you. I'm looking it up right now. Just give me 1 second, Your Honor.
Excuse me.
Can you please exercise your right to remain silent?
Yes, sir.
Please, Mr. Murray.
Yes, sir.
All right, Your Honor.
Go ahead.
Respectfully, it looks like he never was arraigned on those matters. For the 219th district, court, it says that he was scheduled for arraignment on 12/5/24, and that's when the failure to that's when he got a failure to appear on 12/5/24, in which that could be due to that could be due to the notice, him not even knowing that the case existed. And according to the 34th district court, it's scheduled for the show cause arraignment pretrial. So it looks like they set the they kept resetting the pretrial and arraignment. I guess they reset it again like they did in the 19th district court, I guess, to give him an opportunity to get notice. And that one also looks like he didn't get notice. That one also looks like he didn't get notice for he may have not got notice for that one. No, you can see that it says notice generated on it. So I don't want you to think that it's saying that on the court side. The notice was generated, it was sent out, but my client did indicate to us that he did move. He indicated to our office that he was living with his fiance about 10, 11 months ago, and that he recently moved with a friend. So that could be potential that the court didn't have updated address for him. I shouldn't say correct address, but they have an updated address for him, and he received notice of these warrants. So it's not like my client is trying to run or is just not showing up to court because he knows about court, Your Honor. And I don't think that's an indicia that he will run from this matter or that he's a flight risk. In this matter, he was arrested. He was arrested. He's in jail. He has a magistrate that's going to tell him the court proceedings, and he understands that he has court proceedings against him. For those other cases, is a possibility that he never even knew those proceedings were against him at the moment.
Okay. And it's also a possibility, counsel, a bird that he already knew about it, and it's his responsibility that if he knew about it, that he should update the court as to his new location.
Can we ask?
But neither of us, counsel, neither of us were present. So we can only make speculation as to what is happening.
Right. I'm just asking the court not to make a speculation that he tried to run from those cases.
No, I'm not making a speculation. I'm making that he did not show up. Okay. He may have known about it, he may not have known about it. Court was not present as to that. But the court takes everything into consideration. Sergeant Kozak, was there anything else you wanted to add?
That'd be it, Your Honor.
Okay. All right. Counsel Byrd, anything else you wanted to add that's new?
You mind if I voir dire my client?
Go ahead.
Why didn't you show up to court for those for your previous matters, Mr. Brown?
Thank you for the time to be able to put this into context just a little bit. On 12/5 is the day my daughter was born at the hospital in Dearborn at Garden City. I had no idea that I was even in any trouble. They asked me to leave out of the hospital because I guess I was being a little bit too loud. So I was taken down. I was taken to my house, and they never gave me a ticket, though, is what I'm saying. They never gave me any paper. I didn't get a ticket. I didn't get any.
Okay.
So I didn't know.
All right, Mr. Brown?
Yes, ma'am.
Okay, you don't need to say anything else. Counsel Byrd, are you finished with your voir dire?
I'm finished, Your Honor.
Okay, all right. So, Mr. Brown.
Yes, ma'am.
I'm not going to take a position one way or the other as to the other matters. If there are warrants out for your arrest, if there's bond amounts, somebody has to pay that for you to get out of jail. Do you understand that?
Yes, ma'am.
Okay. In this particular matter, I'm going to give you a $25,000 personal bond. I will tell you right now, West Glen District Court does not play around. You don't show up for court, they're going to put a warrant out for your arrest. The amount's going to be high enough When you sit in jail, nobody is going to be able to probably pay that amount of money, even though you say, please, please give me a chance. This is your one chance. Do you understand that?
I do understand that. Thank you so much, Your Honor.
Okay. All right. Sergeant Kozak, you want to place anything else on the record?
No, Your Honor.
Thank you. Council Byrd, anything else on the record?
Nothing further, Your Honor. Thank you.
Okay, that concludes the arraignment of Mr. Brown. Good luck, folks. And Mr. Brown, tell the mother of your child, happy Mother's Day.
Thank you,
Have
Mom.
a good day.
Thank you so much.
No problem. Bye-bye.
And we just got to finish up these 2 add-ons, Your Honor.
Yes, I know. So get those done. You ready? Is Council Reagan, is he interviewing?
He is.
Okay. So we can start the arraignments.
All right, give me 1 second. I'll be right back.
Okay. Miss Marcia. There's that one. It's Mullins. Yeah, sure it is. We don't need to do this one. Marcia, did you pull up the investigative report on Mullins? Yes, please. Wait. You want the paperwork? You want the investigative report?
No, I don't need it.
Okay, toss it out there. Once it's ready. Sign it. I only have to do 2 more, Warren and Brown. EDC.
How you doing, Your Honor?
Hello, sir. How are you?
Grading yourself?
Good. Let me ask you, do you have a Mr. Hodge personal protection order violation?
Let me check. I do believe so. I have to print out the new list.
Okay, Mr. Hodge is just a PPO. He doesn't need an attorney. I just need to arraign him.
Okay, give me 1 second because they just added someone to my list.
They added two more, a
Yeah.
Harrison and a Duhart.
Yes, can you give me 1 second so I can grab those two?
Yes,
You don't-
just need, yeah, I'll give you the moment to get Mr. Hodge.
All righty. Hey, Brandon. Can somebody grab here and part for me? No, yes, Your Honor. I didn't have some black one.
Black one?
Yep, gotcha.
All right, DDC, I need the camera on. Sir, what's your full name?
David Eric Hodge.
Uh, David Eric Colin Hodge?
Yes, ma'am.
Thank you, sir. I'm Magistrate Tartasser. You're here on a criminal, not a criminal matter, a civil matter. It's a personal protection order violation. The case number is 24-108670 PH, sir. You're gonna have a hearing, sir, tomorrow, May 12th, 2025, 9 o'clock in front of Judge Miller Martin. Do you understand that?
Yes, ma'am.
It is over at the City County Building. It's also known as the Coleman
Young.
Young Municipal Center.
Yes, ma'am.
Okay, sir, one bond condition, sir, is you're not to have contact with Kimberly Irving. Do you understand that, sir?
Yes, ma'am. May I add something real quick, Judge? I know this is usually not time.
Sir, you have the right to speak, but understand everything is being recorded and it can be used against you later on. What is it that you want to say, sir?
So, this bond violation is completely false. Miss Irving ran up,
Okay,
was in my cousin's.
that's fine. That's fine. Okay, all you gotta do, I understand that you're saying it's completely false, but that's something that you need to take care of with Judge Miller Martin. Do you understand that?
Yes, ma'am. I'll even go to my other property that's on the other side of town. Maybe we could do that.
Okay, sir, in this particular matter, sir, you're gonna be remanded to the county jail and you're gonna have your hearing date tomorrow, okay?
Okay.
Okay, that concludes your arraignment, sir. You have a good day.
I don't know.
Council Byrd,
Yes, Your Honor.
are you ready?
Ready.
Okay. DDC, we can go down the list.
Hey, go. Can you grab these two for me? Okay, here. I'll see the next. Yo. Next one, got on the finish. Sure, I get that short photo.
Sir, what's your name?
Colonel Dwayne Anthony.
Thank you, Mr. Anthony. I'm Magistrate Chuck there, sir. You're here on a criminal matter. Case number is 240-608-6601. You have an attorney, Council Byrd. You wait for my reading and stand mute.
I do, Your Honor.
When enter plea of not guilty, court dates are May 19, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Robbins. Mr. Anthony, while this case is pending, you're not to possess any firearms or any other dangerous weapons. Do you understand that, sir?
Yes, ma'am.
That being said, this is from August 2024. Charge is non-assaultive. I don't see anything to indicate that this was combative or assaultive behavior. You're eligible for a personal bond. I don't see you as a danger or as a flight risk. Council Byrd, any objection to personal bond?
Not at all, Your Honor.
$5,000 personal bond, sir. Nobody has to pay money for you to get out of jail. Good luck. You can step aside.
Thank you.
You're welcome. Sir, what's your name? Mr. Bynum, this is Magistrate Charte. You're here in a criminal matter, case number 250-573-6701. Sir, you have an attorney, Counsel Byrd. Do you waive formal reading and stand mute?
I do, Your Honor.
Thank you. I'm gonna enter a plea of not guilty. Court dates are May 19, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Taylor. Mr. Bynum, while this case is pending, sir, some bond conditions. There is no assaultive or combative behavior on your part. There's no drinking or possessing any alcoholic beverages. There is no driving of any automobiles, mini bikes, motorcycles, construction vehicles or machines. Do you understand those bond conditions, sir?
Yes, Your Honor.
I see that he has metropolitan ties. Go ahead, Counsel Byrd.
One moment, Your Honor. "29-year-old lifelong resident, Your Honor, indicates to us that he has 2 children, lives with his girlfriend and kids. Indicates to us that he was forthcoming about his prior criminal history. Indicates to us that it is non-assaultive. He is employed, Your Honor. Respectfully, I do understand the seriousness of these allegations, but we'd be asking for a personal bond in this matter."
I will also indicate that Mr. Bynum, he has a prior conviction from March of 2022. And he has this allegation of drinking and driving. Okay, so what's going to happen is Mr. Bynum condition alcohol tether. I also see from the allegations in the investigative report that you appear to be somewhat combative with the police. Okay. I believe that they had to do a spray, OC spray, maybe the same thing as pepper spray, to get your compliance. So you have $25,000 personal bond. Nobody has to pay any money for you to get out of jail. But you understand all those bond conditions I gave you, sir?
Yes.
Okay. That concludes your arraignment, sir. You can step aside.
Okay.
Stand by, gentlemen at DDC. Gentlemen at DDC, what's your name, sir?
Is it Natalia Lozano?
Cesar Tomas Gonzalez Lozano, sir. I'm Magistrate Charte. You're here on 2 criminal matters. First case is 230-605-6701. Date of offense is June 17, 2022. The charge is check non-sufficient funds, $500 or more. Second case is 230-605-6601. Date of offense, June 15, 2022. Count is check non-sufficient funds, $500 or more. These are a couple of cases that are older. Council Byrd, you wait for me reading and stand mute.
Do, Your Honor.
Okay, thank you. I'm gonna enter plea of not guilty. You have the same court dates for both matters, sir. May 20th, 2025, probable cause conference, followed by preliminary examination, May 27, 2025. The charges are non-assaultive. I see that you have local ties here in the city of Detroit. So I'm gonna give you a chance, Mr. Gonzalez Lozano. I'm gonna give you a $10,000 personal bond on each matter. Council Byrd, any objection?
No objection, Your Honor.
Okay. So for both matters, $10,000 personal bond. Nobody has to pay any money for you to get out of jail. That concludes your arraignment on both matters, sir. You can step aside. Yep. Okay. What's your name, sir?
Isaiah Giovanni Stovall.
Stovall. Sir, this is Magistrate Chartea, sir. You're here in a criminal matter. Case number is 250-575-6101. You have an attorney, Council Byrd. You wait for my reading and stand mute.
Your Honor.
I'm gonna enter plea of not guilty. Court dates are May 19th, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Robbins. Mr. Stovall, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes.
That being said, Mr. Stovall, my understanding is this case involved an expired CPL. So, sir, unless you have something to indicate that your CPL is still valid, once it expires, if you have not renewed it, you can't carry a concealed weapon. Do you understand all that?
Yes.
Okay, I believe you were forthcoming. So in this particular matter, bond is going to be $5,000 personal bond. Court doesn't see you as a danger or as a flight risk. Council Byrd, did you want to add anything else for the record?
Nothing further, Your Honor. Thank you.
Thank you. Thank you, Mr. Stovall. You can step aside.
Take it off.
Take this one?
Yeah.
Oh, this is Mr. Warren. Oh, yeah. You want it back?
I mean, yeah, but I just, yeah.
Okay, here you go.
You got one more for me coming in a minute.
I know, Brown. Gentlemen at DDC, what's your name, sir?
Joshua Humphreys.
Okay, thank you. Mr. Humphreys, I'm Magistrate Chartea, sir. You're here in a criminal matter. Case number 250-575-6201. You have an attorney, Council Byrd. You wait for my reading and stand mute.
Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are May 19th, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Robbins. May 19th, May 23rd, Judge Robbins. Understand those court dates, Mr. Humphreys?
Yes, ma'am.
With that being said, Mr. Humphreys, bond conditions. You're not to possess any firearms or any other dangerous weapons. Understand that?
Yes, ma'am.
With that being said, you appears you have local ties, charges non-assaultive. I don't see anything else to indicate that you are a danger or flight risk. Sir, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Council Byrd, any objection to that bond?
No objection, Your Honor.
Thank you. Sir, you can step away from the camera. That concludes your arraignment.
Black man.
Sir, what's your name?
Ando José Guillermo.
Your full name?
Fernando José Guillén Betanco.
Julian Petanco?
Guillén Betanco, yeah.
Okay. Sir, I'm Magistrate Chartea. You're here on a criminal matter, case number 250-5756301. You have an attorney, Counsel Byrd. You wait for my reading, stand mute.
Your Honor.
Thank you. I'm gonna enter a plea of not guilty. Sir, you have court dates, May 21st, 2025, probable cause conference, followed by preliminary examination, May 28th, 2025. Both matters are in front of Judge Taylor. Do you understand the court dates?
Yes.
Okay, let me tell you some bond conditions, sir. One, you are not to go back to the mobile gas station on Verner. Do you understand that?
Yes.
You're not to have any contact with, I believe, a clerk, Saeed Hamdan. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Do you understand that?
Yes.
Okay. Let's see. I see that he has metropolitan ties. Counsel, go ahead, ask your bond, please.
25 years old, Your Honor. Lives with a friend at this moment. Been in Michigan now for 9+ years. Indicates to us that he doesn't have any pending cases, not on probation or parole. He is employed, Your Honor, does carpet and flooring. Days and hours vary. I do understand the seriousness of these allegations. My client is not trying to run from this matter. And respectfully, we're going to ask this court for a personal bond.
Mr. Julian Petanco, there is no drinking or possessing of any alcoholic beverages. Do you understand that?
Yes.
Counsel, he has prior conviction of drinking causing serious injury from 2021. So with that being said, I'm gonna give him a chance, and he's gonna get a $25,000 personal bond. Mr. Gulian, is it Gulian or Julian?
Guillén.
Guillen, is it Mr. Guillen Betanco? Sorry, nobody has to pay any money for you to get out of jail. Do you understand that?
Yes.
That concludes your arraignment. You can step aside. Sir, what's your name?
Gregory Kyle Arthur, Your Honor.
Gregory Kyle Arthur II?
Yes, ma'am.
All right, Mr. Arthur, I'm Magistrate Chartea. You hear a criminal matter, case number 250-5756401. Counsel Byrd, you wait for my reading and stand mute.
I do, Your Honor.
An enter plea of not guilty. Court dates are May 20th, 2025. It is a probable cause conference, followed by preliminary examination, May 27, 2025. Both matters are in front of Judge Giles. Okay. Mr. Arthur, while this case is pending, let me give you some bond conditions. There is no driving of any automobiles, mini bikes, motorcycles, while this case is pending. Do you understand that?
Yes, ma'am.
There is no assaultive or combative behavior while this case is pending. Do you understand that?
Yes, ma'am.
Let's see. Okay. All right. I see that he has local ties, convictions, 2010, 2012, 2016. None of them appear to be assaultive. Go ahead, Council Byrd.
Indicates to us that he's a barber, Your Honor, 35 years old, lifelong resident of Michigan, 5 children who he helped raise. Respectfully, Your Honor, we're gonna ask this court for a personal bond in this matter. It looks like
Understand. Go ahead, Council Byrd. You
Oh,
want to
no,
say
go
something
ahead,
else?
I was just saying, it looks like it's more resistant than assaultive to a police officer too, you know.
Right. So, Mr. Arthur, I'm gonna give you a chance, sir. I'm gonna give you 50,000, 50,000 personal bond. Nobody has to pay any money for you to get out of jail. $50,000 personal bond. Please obey the bond conditions. Go to court when you have to. Do you understand all that, sir?
Yes, Your Honor.
Okay, good luck. That concludes your arraignment. You can step aside, sir. What's your name, sir?
David Junior Harris.
Thank you. Mr. Harris, I'm Magistrate Chartea, sir. You're here on a criminal matter, case number 250-575-6601, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor, Brandon Byrd on behalf of David Harris, my client waived his right to the formal reading and will stand mute.
Thank you. I'm gonna enter plea of not guilty. Court dates are May 19, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Jefferson here at 36th District Court. Mr. Harris, while this case is pending, you're not to possess or use any illegal controlled substances. Do you understand that, sir?
Yes, ma'am.
Okay, so what I see here for the charge is non-assaultive, he has local ties. Looks like he has 2 convictions, narcotics, 1 larceny from a person. And let's see. Looks like 2019 is the last conviction. Go ahead, Council Byrd.
Respectfully, Your Honor, it is a possession of less than 25 grams. Non-assaultive allegation, 45 years old, lifelong resident. I don't believe him to be a flight risk or a threat to the community. We're gonna ask this court for a personal bond.
Thank you. Mr. Harris, I'm gonna adopt that recommendation. I'm gonna give you a $15,000 personal bond. Nobody has to pay any money for you to get out of jail. But sir, please stay away from narcotics. Go to court, handle your matters. Good luck, sir.
Thank you.
What's your name, sir?
Lorenzo Mario Stevenson.
Thank you, Mr. Stevenson. Sir, I'm Magistrate Chartea. You're here on a criminal matter, case number 250-575-6701. Council Byrd, you wait for my reading and stand mute.
I do, Your Honor.
Thank you. I'm going to enter plea of not guilty. Sir, you have 2 court dates, May 21st, 2025, probable cause conference, followed by preliminary examination, May 28th, 2025. Both matters are in front of Judge Taylor. Mr. Stevenson, while this case is pending, you're not to possess any firearms or any other dangerous weapons. Do you understand that, sir?
Yes, ma'am.
Okay. With that being said, counsel, I see that that it is not assaultive. I see that he has prior convictions. It looks like they're all non-assaultive relating to drugs. 2009, 13, 2014 seems to be the last conviction. He does have local ties. This appears to be a delivery and or possession with intent to deliver. Council Bird, go ahead as to anything else.
Respectfully, Your Honor, lifelong resident of Michigan also. Don't see him to be a flight risk, non-assaultive, not a threat to the community, Your Honor.
Okay. Well, Council Bird, dealing with narcotics, it can be a danger to the community if he is selling, giving away narcotics, but I will leave the trial court to deal with that. Mr. Stevenson, $25,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, sir?
Yes, Your Honor.
Good luck. DDC,
Yes, Your Honor.
do you have a Jeffrey Rowland?
Yes, Your Honor. I'm trying to get him to the camera right now.
Okay, thank you.
We're also ready on the add-ons too, Your Honor.
Okay. Let me see, Harrison. Mr. Rowland, stand by for a moment. Mr. Rowland, please say your full name.
No, this is not rolling, Your Honor. This is Duhart.
Oh, Duhart. Okay, so you don't have Mr. Rowland yet?
I'm trying to get him to the camera next.
Okay, all right. Mr. Duhart, please say your full name.
Duhart.
Full name.
Oh, Marquise D'Angelo Duhart. I'm sorry.
Thank you, Mr. Duhart. I'm Magistrate Chartea. You're here on a criminal matter, case number 2505756-901, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of Marquise Duhart. My client waives his right to the formal reading and will stand mute.
Thank you. Evidentiary plea of not guilty. Court dates are May 19, 2025. Probable cause conference followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Robbins. Understand those court dates, sir?
Yes, I do.
Okay. Mr. Duhart, will any firearms or any other dangerous weapons? Do you understand that, sir?
Yes, I do.
Go with them.
That being said, okay, I see that he has metropolitan ties. Charge is not assaultive. I don't see any in the file to indicate that he is a danger or flight risk. So, Mr. Duhart, I'm going to give you a chance. I'm going to give you a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that?
Yes, I do. Thank you.
Okay. Council Bird, no objections, correct?
Correct.
Okay. Thank you, Mr. Duhart. That concludes your arraignment.
Hey, have a good one. Thank you.
Thank you.
Come on, Roland.
Sir, please say your full name.
F3 Allen Road.
Mr. Rowland, I'm Magistrate Chartea. You're here in a criminal matter, case number 230-554-5801. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of Jeffrey Rowland. My client waives his right to the formal reading and will stand mute.
Enter plea of not guilty. Court dates are May 19, 2025. It is a probable cause conference followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Taylor. Mr. Rowland, let me tell you some bond conditions. One, you're not to possess any firearms of any kind or any other dangerous weapons. You're not to possess any ammunition of any kind. Let's see. I'm making sure that is on your paperwork. You're not to have contact with Salvador Cabrera. You see, who else? Let's see what the investigator's report says. You're not to have contact with a Matthew Bellew. So those two individuals, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Let's see what else. You're not to go back to the 8848 Witt Street here in the city of Detroit. Do you understand that bond condition, sir?
Yeah, yes, ma'am.
Okay, so you understand so far all the bond conditions I've given you?
Yes, ma'am. And also, just, I live at
Hold
88.
on, sorry, as long, Mr. Rowland, I just want to make sure that you understand those bond conditions.
Yes,
You
ma'am.
have an attorney that's going to speak for your behalf, on your behalf. Okay, Council Bird, go ahead, please.
44-year-old, 44 years old, Your Honor, indicates to us that unfortunately he's unemployed. Any amount of bond is going to be very difficult for my client to pay. This has an incident date of roughly almost 2.5 years now, going almost 2.5 years now, Your Honor. Respectfully, my client indicates that he hasn't seen the complaining witness in years. He also indicates to us that he needs a doctor. Needs a doctor because when he was arrested aggressively. And if we can mark his file medical, it'd be greatly appreciated. I do understand the seriousness of these allegations, but there aren't any allegations in front of us that my client displayed this type of behavior or has been convicted of anything in between this time. I respectfully, Honor, I know most likely it won't be a personal bond, but we're going to ask for at least a low, reasonable bond so he might have some sort of chance to getting out. Respectfully, ideally, we'd like a personal bond, especially since he showed that he could go for a specific amount of time since this incident date without any indication that he has any other cases at all. But if this court's not inclined to that, then at least a low or reasonable bond, yeah.
Thank you. All right, I've heard the representations of defense counsel in this particular matter. Mr. Rowland, another bond condition, sir. There is no drinking or possessing of any alcoholic beverages. DDC, can you mark Mr. Rowland's file medical?
Yes, Your Honor.
Can you tell me, does he have any holds on him right now?
He has a Third Circuit Court hold, Your Honor.
Does it say what it's for?
No, it does not.
Okay, I see Mr. Rowland has a number of priors going from 1997 and going forward. Receiving concealed stolen property, carrying concealed weapon 1997, 1999, receiving concealed and stolen property, fleeing police, felony narcotics, 2004, 2018, assault dangerous weapon. So misdemeanors, drinking and driving, 2011, failed to stop, auto accident. And he has a circuit court hold. So in reading the allegations in the investigator's report, it does show that supposedly Mr. Rowland, and they are only allegations, the court has taken into consideration that this is about 2.5 years old, that he had been drinking. He approached both individuals, Cabrera and Belu. He shot one of the individuals. Allegedly, he made a statement that he wanted to kill everybody. Let me see. I read that. Let me make sure if I have that correct. Supposedly screaming, I have nothing to live for, and I'll kill your whole family. Mr. Cabrera ended up going to hospital because he was shot. So he appears to have some sort of assaultive behavior from his past. So he is going to get a monetary bond using clear and convincing evidence standard. The court does find that he is a danger, but he's also going to get a bond redetermination date. DDC,
Yes, Your Honor.
can you tell me, did Mr. Rowland, is there any information that he surrendered?
Oh, Your Honor, he was arrested at a location on Whap.
Okay, so this is, bond is gonna be $100,000 cash surety, which is unaffordable, correct, Council Byrd?
Correct, Your Honor.
Okay, he's gonna get a bond redetermination for this Wednesday, which is May 14th. And I believe I have it on, yeah, May 14th, 2025, 9 o'clock in front of Judge McConicle, who's going to look at the bond amount and bond conditions. Do you understand that, Mr. Rowland? You're getting another court date this Wednesday. Another judge is gonna look at your bond amount and bond conditions.
Next year, doctor, I've been requesting.
Yes, I had him marked your file medical, so hopefully you can see a doctor today or tomorrow, sir. That concludes your arraignment. Council Byrd, did you want to add anything else?
Nothing further, Your Honor.
Thank you, sir. All right, BDC, I'll see you on the female side.
Okay, Your Honor.
Thank you. Here, Ms. Garcia. Young lady at DDC, what's your name, ma'am? Ma'am, you need to speak or you need to be unmuted. What's your name again? What's your name?
Harrison.
Ivory.
Yes.
Ivory Faye Harrison, is that correct, ma'am?
Yes.
Thank you, ma'am. I'm Magistrate Chartea. You're here at criminal matter, case number 25057568001, ma'am. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brendan Byrd on behalf of Ivory Harrison. My client waived the right to the formal reading, was advised to counsel the rights, and will stand mute.
Thank you. I'm going to enter a plea of not guilty. Court dates are May 20th, 2025, probable cause conference, followed by preliminary examination, May 27, 2025. Both matters are in front of Judge Giles. Okay. Ms. Harrison, while this case is pending, you have some bond conditions. One, you're not to possess any firearms or any other dangerous weapons. Do you understand that?
Yes.
Two, you're not to have contact with a Donnelly Let. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, ma'am?
Yes.
Okay. Council Byrd, go ahead.
One moment, Your Honor. "24-year-old lifelong resident, Your Honor, indicates to us, that she doesn't have any prior criminal history. It's not on probation or parole, and no pending cases. Unfortunately, she's unemployed. Any amount of bond is going to be difficult for my client to pay. I understand the serious and severity of these crimes, and that's why I had to take a chance to read this report, Your Honor. My client indicates that she was jumped because she owed the defendant $5. She doesn't really know the defendant, seen him around, and indicates to us that that's what happened. She was defending herself in this matter, and I believe that might be why the complainant stated that he doesn't. One of the complainants stated that he does not want to participate in the photo lineup, nor did he wish to press charges, because if the facts came out, we see that my client at least was the only person that had to go to the hospital. Both of them refused EMS, but unfortunately, my client needed stitches in her finger, had swelling on her ankle and the left side of her face, and she was being beat pretty badly. Uh, I do understand under normal circumstances, there'll probably be no way possible to get a personal bond. But if there's any circumstance that deserves a departure, I believe it'll be this one, Your Honor. My client doesn't want any contact with the complainant witness at this point. The officers did say they seen that they were wrestling over a gun, and that they were wrestling over a gun at the location, in the front of the location. I'm not sure if they observed that personally on video, Your Honor, but respectfully, that's what it says. That's what it says at the beginning. But my client wants to indicate to us that she was the one getting beat. We can see that still swelling on the side of her face. Um, and she has stitches in her finger. Like, she's the only one that took a beating in this matter. So that does kind of give some sort of credibility to what she told the police, in which she was the one being assaulted and jumped and trying to protect herself. So she doesn't have any problem staying away from the complaining witness, Your Honor. And she does live at a location. She does live at a location in which she has the ability to stay away from the complaining witness. She was arrested at the gas station, but that was on the same day. And we're gonna ask this court for a personal bond in this matter, Your Honor. If this court is not inclined to a personal bond, then a personal bond with a GPS tether.
Thank you. Court heard the representations in this particular matter. Uses clear and convincing evidence standard. When it's entertaining monetary bond, court is entertaining monetary bond. We started off with personal bond basis. Court read the allegations in the investigator's report. It does show that there are witnesses to indicate that the complaint and that the defendant were wrestling and that the complaint needed assistance. And it appears that there is some video that shows that both the complainant and the defendant fall to the ground, that both defendant and complainant are wrestling. See that the complainant on top of the defendant attempting to take a firearm. They observe that other individual calls the police, calls 911. Court has noted that the complainant doesn't wish to press charges, but it's not up to the complainant. It is up to the Wayne County Prosecutor's Office in this particular matter. The court does find that Ms. Harrison, she is a danger. We are going to give her $100,000 cash surety, and as counsel has indicated, any amount would be unaffordable. Court is going to give her a bond redetermination for this Wednesday, May 14, 2025, 9 o'clock in front of Judge McConigal, who will look at the bond amount and bond conditions. That concludes Ms. Harrison's arraignment. Ma'am, what's your name?
Kenosha Pando,
Your full name?
Kenosha Ashawn Pando.
Thank you, ma'am. I'm Magistrate Chapter. You hear the criminal matter, case number 250-5756-501. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Kenosha, Brandon Bird on behalf of Kenosha Panda, my client waives the right to the formal reader, was advised of constitutional rights, and will stand mute.
Thank you. I'm going to enter plea of not guilty. Court dates May 19, 2025, probable cause conference, followed by preliminary examination, May 23rd, 2025. Both matters are in front of Judge Shakay. Ma'am, while this case is pending, you have some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you're not to have contact with Lucas Taufik Gago. When I say no contact with that individual, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to go back to the address that's on Roche Drive in Macomb County. Do you understand those bond conditions, ma'am? I'm gonna take away that bond condition about no contact with the address in Macomb County. This location, the incident looks like indicated or occurred at the defendant's residence. So the complaint looks like resides another location. Go ahead, Council Bird, that's the bond.
28-year-old lifelong resident of Michigan, Your Honor. Indicates to us out her 28 years of life that she doesn't have any prior criminal history, not on probation, parole, no pending cases. She is employed, but still will be able to afford the bare minimum. And graduated with a BA with a bachelor's degree in film production, Your Honor. So she has shown that she could be in a structured environment and finish it. But my client indicates that the complaining witness in this matter is completely lying. First of all, indicates to us that he cut his hand punching the wall. He threw a step stool at her. Said she never stabbed him. He gets violent when he watches porn. He became angry and started throwing things. He's aggressive. They live together in an RV because the house is being renovated and she owns the property where they were living together in the RV. He punched her and threw stuff at her. She was defending herself, Your Honor. And respectfully, she has bruises and he wouldn't allow her to leave. Injuring her shoulder and foot and multiple other parts of her body. So respectfully, Your Honor, I do understand this is a serious assaultive allegation. As we see, it's going to be no problem with them having no contact. Having no contact. My client doesn't want any contact with this complaining witness at this moment, Your Honor. And we're going to ask the court for a personal bond.
Thank you. Court uses clear and convincing evidence standard when it's entertaining monetary bond. Started off with a personal bond basis. Allegedly occurred May 9th this year, just a couple of days ago. Anything in the file to indicate that she has any priors. Reading the allegations in the investigator's report is that supposedly the complainant was hit multiple times all over his body, hit on the head with a pot, also, and allegedly stabbed. And that allegedly also that the defendant threatened to kill him, stab him in the neck and kill him, and did raise the knife and attempt to do so. However, the complainant was able to grab the arm to prevent the defendant from stabbing him again. Let's see, laceration, hair loss from his scalp, declined medical attention. Okay. Court does find that this defendant is a danger. Counsel, is any amount an unaffordable amount?
She could afford about $300, you know.
In this case, bond is going to be $25,000, 10%. Court does find her to be a danger. I am gonna 25,000, 10%. And make sure I repeat that. $25,000, 10%. Bond redetermination will be this Wednesday, May 14th, 2025, 9 o'clock in front of Judge McConigal. Ma'am, if you're not able to pay $2,500 or nobody able to pay for you to get out of jail, we're going to have another court date this Wednesday. Somebody's going to look at the bond amount, a judge is going to look at the bond amount and bond conditions. Do you understand that? Okay, that concludes your arraignment. DDC, is that it?
Yes, ma'am.
Okay.
Happy Mother's
Thank you.
Day. All right.
Thank you. Take the ladies, tell the ladies in your life, Happy Mother's Day.
It will.
Happy Mother's Day to all the ladies.